Well, ladies and gentlemen, welcome to yet another episode of Ask Johnny D. As you know, I'm John DeGasperis, the PI guy. And tonight, we have another series of questions submitted by my loyal viewers. Thank you, as always, for your participation. I'm very excited. This is our 5th week doing Ask Johnny D. My friend Paul and I have been dedicated every week. We're in here trying to make this better. We're talking about how we can't wait for the office space at 303 Clinton Avenue to come along so that we have a legitimate desk and we can be comfortable. And I talked with my hands, so we got to figure that out. Our lighting is improving. We're getting the camera work down. Paul's edits are phenomenal. I hope you all enjoy watching this stuff. We're having a lot of fun producing it. So here we are, week 5, question number 1. Comes from Caitlin of Saugerties. She wants to know, quitting after maternity leave. This was my plan all along, but I never did my research. And now I'm reading, I can be held responsible for health insurance premiums and disability. Is this true? Caitlin, it depends whether you took maternity leave under state or federal law. Under federal law, there is no formal maternity leave, nor are there maternity leave benefits. There is, however, the Family Medical Leave Act. People who have new children often take time off of work. Under the Family Medical Leave Act, if you do so, you may be obligated to repay health insurance premiums that were paid on your behalf during your absence. You may also be obligated to repay any wage benefits that your employer voluntarily paid to you. Okay, so that's the status under federal law. Now, I did some research about New York State's law. In New York, the maternity and paternity leave law and benefits are set forth in the workers' compensation law. Now, there was major changes made to the workers' compensation law as it relates to maternity and paternity leave. These changes occurred in 2017 and arguably made New York State one of the most progressive states as it relates to the benefits afforded to new parents. Now, under New York State law, employers are required to carry some form of insurance plan that will pay benefits, wage benefits, to employees who take a certain amount of time, I believe it's 26 weeks off of work after the delivery of a new child. Now again, those benefits are paid through an insurance plan. Many employers, however, offer a more generous or lucrative maternity or paternity leave plan. And so I think the real question here is, do you have a contract with your employer? Are you a member of a union who maybe is part of a collective bargaining agreement? I think that you need to check the terms of your employment with your employer to understand whether or not your employer requires you to repay any benefits or insurance premiums paid on your behalf during your absence. My research did not yield any case law or other information to suggest that you have to repay benefits paid to you under New York law. I also want to be clear that you have the right to quit anytime that you want. So don't feel compelled to stay at your place of employment if you don't want to. But on this question of whether or not you're obligated to repay benefits under New York law, it looks like the answer is no. But again, check any contract that you might have. Check your collective bargaining agreement. That's all I have on the topic of maternity leave benefits. Caitlin, thank you for your question. I learned a lot in researching the answer. Question number 2 comes from Brandon. Brandon lives in upstate New York. I love Brandon's question because it's right up my alley and I have experience with the facts of Brandon's question. Brandon is a homeowner. He hired a snowplow contractor who leaves a giant mound of snow in the road. The mound of snow causes a car accident. Who's at fault? Everybody. I'm suing everybody. Here's why. We really don't know who's at fault until we dig in. We start litigation, we exchange discovery. All parties exchange pictures, eyewitness accounts. Maybe there's video. Maybe we can go look at the scene to see how everything lies and what it looked like. Once we know all of those things, it's easier to analyze who is at fault. But I will tell you, both you as a homeowner and your snowplow contractor are vulnerable. Now, normally, a limited contractual duty of a snowplow contractor to remove snow from your property will not expose the contractor to a tort claim for personal injuries caused to a third party, here the driver of the car. However, there is a body of law that suggests when the snowplow contractor fails to exercise his duty in a reasonable manner and then launches an instrument of harm, then the snowplow contractor can be held liable. Okay, so here, by pushing that mound of snow out into the road, I would say the contractor launches an instrument of harm. You also, I think, are on the hook, because if you see that plow contractor push that mound out there, or if you know that the mound is out there, I would argue that the homeowner similarly created a dangerous condition that caused or contributed to the cause of an accident. And so that's why I think ultimately I would initiate a case against both the homeowner and the snowplow contractor. Maybe at the end of the day, one party has more liability than the other, probably your snowplow contractor. But good news, if you have homeowner's insurance, your homeowner's insurance policy is undoubtedly going to cover that accident. The policy will cover the injured party's damages and will also cover your legal expenses. So certainly this situation is not ideal, but if you're insured, you're secured. And we would hope that you contracted with a legitimate snowplow contractor who not only has insurance on the vehicle, but probably or preferably would also have a general liability policy that would cover business acts or torts committed during an act of business. Everybody's going to be insured here, I hope, and the insurance companies will hash this out. The jury would decide, if this case were to go to a jury, the jury would decide who was at fault, and the jury would be asked to apportion liability by percentages on the driver of the car, because maybe he or she contributed to his or her own demise by being distracted and not seeing the pile in the road. Maybe the snowplow contractor has some or all of the responsibility, and like I said, maybe you as the homeowner bear some level of responsibility. So ultimately, a jury would be asked to apportion liability based on percentages, and all parties would be responsible for paying the percentage of fault. So if you had a verdict for $100 and you were 100% at fault, you owe the entirety of that $100. If you were found only 50% at fault, you only pay $50. And if the injured party or the plaintiff is found to be at fault by any percentage, then that percentage is deducted from the final verdict. So if the driver was found to be, say, 20% at fault for failing to be careful or failing to see what there was to be seen in the roadway, well, then there would be a 20% reduction in the verdict. So, Brandon, I hope you're insured. Don't be offended when I sue you, because ultimately justice will prevail.